Mara, standing in a corridor that smells like industrial cleaner, taking a photograph of a chair. Not of her mother, of a chair. I had to sit with that image for a moment before I understood what she was doing and why it mattered. You're watching Eternal Diary. My sister got power of attorney. She went to prison for elder abuse within a year. The first time I drove to Thornfield after Arabella moved our mother there, I noticed the smell before I even opened the car door. Antiseptic layered over something underneath it that antiseptic was not strong enough to cover. Boiled food maybe, disinfectant on top of something that should have been addressed rather than masked. I sat in the parking lot for a few minutes with the engine still running and the heat vent on my face, and I told myself this was temporary, that it could be addressed, that I had not yet exhausted my options. I had been telling myself things like that for 4 months. Our mother's name was Margaret. She turned 78 the previous March, and for most of my life, she had been a woman who pressed her own clothes and kept a dictionary on the kitchen table and argued with radio presenters out loud. She had strong opinions about sentence structure and weak opinions about television. She had grown up in a house with no central heating, and she never fully lost the habit of wearing 2 layers indoors. The dementia started the way these things always seem to start. Quietly, in the periphery, in places where one individual event could be explained away. A repeated story, a misplaced word, a long pause in the middle of a sentence where she would tip her head slightly and look for something that had gone out of reach. You noticed these moments, and then you watched them pass, and you chose to believe they meant nothing because what they actually meant was too heavy to carry home. By the time she was formally diagnosed, it had been going on for 2 years. I was the one who took her to the appointments. I was the one who sat in the consulting room with a yellow legal pad and took notes while the neurologist explained the staging and the trajectory and what to expect. I was the one who called the insurance company 3 times to get the medication coverage sorted and who vetted 2 different homemade agencies before settling on the one whose coordinator actually answered the phone. I arranged the twice-weekly visits. I set up the medication organizer with labeled compartments for morning and evening and showed the aide how our mother liked things to be done. Arabella sent flowers, and I want to be careful here because I am not sure she was a villain from the beginning. The flowers were beautiful, cream and sage green, from a florist on the north side of the city that she had obviously chosen with care. She texted me a photograph of them with a heart. She lived 40 minutes away. She worked long hours in a role that consumed her, and she had 2 young children and a husband named Adrian who had strong opinions about wine and very little else. She was busy. She was absent. She felt guilty about being absent, I think, which she translated into gestures rather than presence. She sent flowers. I changed the bed sheets. That was the dynamic for the first year of our mother's diagnosis. I was present and exhausted, and Arabella was distant and apologetic in the particular way of someone who has decided their apology is the same as amends. A familiar configuration, almost a cliche. So if I had had the perspective to recognize it, I did not have the perspective. I was too tired. I had worked in healthcare administration for 11 years, not as a clinician, but as the person who understood how the system was organized, which meant I also understood how it failed. The gaps, the handoffs, the points where accountability disappeared because no single person held the whole picture. I had spent a career watching those gaps widen. I knew how to fill them. I knew how to document. I knew that a legal pad was not a record and that a record was not nothing. I kept a box under my desk at home, organized by date. I labeled it in black marker. Margaret, medical. It contained the neurologist's notes and the pharmacy printouts and the care plan from the home aid agency and every piece of paper that had passed through my hands since the diagnosis. It was not dramatic. It was just practice. It was just what I did. I did not know then how important it would become. Arabella's reemergence happened in the autumn of the 2nd year. Our mother had a fall. Nothing broken. She caught herself on the counter and ended up seated on the kitchen floor, frightened but uninjured. She called me, and I drove over, and by the time I arrived, she was in her chair with a cup of tea and a slightly pink look about her that I recognized as embarrassment more than pain. But she had been shaken. The fragility of the moment had made itself visible in a new way. Arabella drove down the following Sunday. We sat together in our mother's kitchen and drank tea and talked around each other in the careful way we had developed since our father died, polite, practical, Not unkind, but not fully honest either. Arabella said she wanted to be more involved. She said the situation was clearly more than I could manage alone, which was true, and she said it with enough genuine concern that I did not hear the other thing underneath it, which was that she had already been talking to a financial planner. The visit ended warmly. Arabella hugged our mother for a long time at the door and said she would be back soon. I drove home in the dark thinking that maybe we would be all right, that we could divide this between us and it would become lighter. I had that particular loosening in the chest that comes from not having to be the only one. I was wrong, but not in the way I was expecting. 3 weeks later, on a Wednesday when I was at work, Arabella came back. She did not tell me she was coming. She arrived at 11 in the morning with pastries from our mother's favorite bakery and a folder of documents and a notary she had arranged through a firm on the other side of the city. I found out about it on Thursday evening. Our mother mentioned it the way she sometimes mentioned things, sideways, in the middle of another conversation, the way details float up when you are not trying to remember them. She said she had signed some paperwork that week, something for Arabella. She said it was so Arabella could help with things if needed. I drove over after dinner. The paperwork was still in the folder on the side table. Why, because our mother did not always clear things away anymore the way she once had. I sat down next to her and picked it up. It was a general durable power of attorney. Signed, witnessed, notarized, effective immediately. It named Arabella as sole agent with full authority over our mother's financial and personal affairs. I read it twice. Then I read the key provisions again. The document was legally complete. The signature looked like our mother's signature. The notary's seal was valid. The witness was present. I set it down and looked at our mother, who was watching a nature program and offering me nothing more complicated than company. I asked her, as carefully as I could, what she understood about what she had signed. She said it was so Arabella could help her with paperwork, that Arabella had explained it clearly. I asked if anyone had suggested she speak with her own lawyer before signing. She said no. I asked if she had felt any pressure to sign it. She looked at me with the particular mild expression she had developed for moments when she sensed I was worried about something she didn't think was worrying. She said Arabella had been very kind about it. I stayed for another hour. I helped her with the medication organizer and I checked the fridge and I washed the 2 cups from dinner. When I kissed her goodbye, she smelled of lavender talc and the particular warmth of someone who has been sitting in a warm room. I drove home very slowly. I sat in my car in my own driveway. I did not call Arabella. I counted 11 minutes on the dashboard clock without meaning to. I was not crying. I was doing something different. Colder. Something that I had not done before and have not stopped doing since. I was thinking, I want to explain something about power of attorney documents because everything that followed only makes sense if you understand what they are and what they are not. A durable power of attorney is not a transfer of ownership. It does not remove a person's right to make their own decisions while they still have capacity to do so. It is a legal instrument that authorizes an agent to act on behalf of a principal in specific or general matters. The word durable means it survives the principal's incapacity. It remains in effect after the principal can no longer make decisions for themselves. Which means that once our mother's dementia progressed to the point where she could no longer reliably manage her own affairs, Arabella would have full legal authority to make every decision in her place, including financial ones. That is an enormous amount of power to concentrate in a single person with no oversight mechanism. The law does contain protections. The principal must have legal capacity at the time of signing. They must understand the document and its consequences. If capacity is in question, the document can be challenged. If the document was obtained through undue influence, pressure, manipulation, or deception, it can be challenged and voided. An agent has what the law calls a fiduciary duty. They are obligated to act in the principal's best interest, not their own. But here is what nobody tells you. Challenging a POA after the fact is slow, expensive, and emotionally relentless. It requires a court. It requires evidence. It requires a judge to look at a signed and notarized legal instrument and conclude that something legitimate looking is in fact not. I knew all of this. I had worked alongside estate attorneys long enough to understand the contours of the tool, which is precisely why I did not call a lawyer that night. I needed to understand what I was dealing with before I moved. I needed to build something before I opened my hand and showed what I was holding. I went inside and took out the box from under my desk. I opened a second folder. I wrote the date at the top in black ink. That was October. By December, Arabella had canceled the home aid. She told our mother it was to save money on what was an unnecessary expense. She told me when I called that the agency had been overcharging and she was finding better alternatives. I asked what the alternatives were. She said she was handling it. The phrase "she was handling it" became Arabella's primary form of communication with me over the months that followed. I asked about medication refills. She was handling it. I asked about the cardiology appointment. She was handling it. I asked if I might come along to provide another set of notes. She said it wasn't necessary. I began keeping a call log. Every call. Date, time, duration, what was asked, what was said. This may read as obsessive. It is not obsessive. It is what you do when you understand that memory is not documentation, and that documentation is what institutions use to determine what actually happened. I had spent 11 years in a system that runs on records. I knew the difference between what someone says happened and what the paper says. I also began visiting our mother more frequently, twice a week instead of once. I brought groceries and checked the refrigerator and looked at the medication organizer and noted what I saw. I took photographs on my phone of small things: the organizer, the fridge contents, a shopping receipt I found by the kettle. Not because anything was dramatically wrong at first, because I understood that small things aggregate into patterns, and patterns are what you have when the individual events have been explained away. By January, the medication organizer was showing irregularities. Our mother was on 4 medications, 2 for blood pressure, 1 for thyroid function, 1 antidepressant she'd been taking since our father's death, which her GP had noted was important for her stability, particularly given the cognitive decline. So the organizer was a 7-day unit with morning and evening compartments. In January, I counted the pills across 3 separate visits, and the numbers did not track against the prescription schedule. The antidepressant was running 3 days behind, not absent, but behind, which meant doses were being missed on a consistent basis. I photographed the organizer each time. I wrote down the counts. I called the pharmacist on a Tuesday morning and asked about the refill dates on record for each medication. Pharmacists can confirm when a prescription was last filled. The antidepressant had not been refilled in 41 days. The schedule required a refill at 30. I noted all of this. Then I called Arabella and said, as neutrally as I could manage, that the antidepressant appeared to be behind schedule and perhaps I could coordinate the refills going forward since I was closer. She told me she was handling it. I added the entry to the call log. I want to be precise here. At this point, I was not certain anything criminal was happening. I was certain that something was wrong. I was certain that Arabella was the legally authorized person responsible for the care and that the care had measurable gaps. Those 2 things together had a shape I recognized from work. We called it a systems failure, a series of individually explicable lapses that accumulate into a pattern of harm. I had started 2 folders. I started a 3rd. February brought the phone call I had been bracing for without consciously knowing it. Our mother called me at 7 in the morning. Her voice was quiet and a little confused, which was not unusual, but underneath the confusion there was a flatness I hadn't heard before, a kind of emptiness in the tone that I did not have a name for at the time. She said she wasn't sure what day it was. She said she thought she might have missed dinner the previous evening, but couldn't quite remember. I drove over immediately. The kitchen was clean enough, but the refrigerator had very little in it. Some condiments, a partial container of milk that was approaching its date, a piece of fruit. There were crackers on the counter and an unopened can of soup. The medication organizer had not been touched in 2 days. Our mother was in her armchair in the living room in her nightgown. She was clean. She did not appear to be in acute physical distress. But she was alone, and it was early morning, and she did not know what day it was, and she had not had a proper meal. The heating had also been set too low. The house was cold in the particular way of a space that had been cold for a while, not sharp, just pervasive, the kind of cold that gets into upholstery. I turned the heating up. I made eggs. I sat with her at the kitchen table while she ate, and I watched her come back to herself slowly, the way a window fogs and then clears, color returning, focus sharpening. By the time she finished eating, she was telling me about a program she had seen the day before, gesturing with her fork. I called the pharmacy and arranged an emergency refill delivery for that afternoon. I stayed 4 hours. I restocked the fridge from a nearby shop. I made sure the medication organizer was properly filled for the next 7 days. I put a note on the refrigerator with a simple daily checklist: breakfast, medications, lunch, because sometimes the structure helped. I drove home and called Arabella. She said she had visited 3 days ago and everything had been perfectly fine. She said our mother got confused sometimes. She said this was the nature of the condition and that I was treating it as though it were a management failure rather than a medical reality. She said I was catastrophizing. I was recording the conversation on my phone. I had checked in November whether this was legal in our state, single-party consent. One person in the conversation can record without notifying the other party. This is legal in our state. I added the recording to my documentation. The following week, I made an appointment with Josephine. I found her name through a colleague in my department. Not a close colleague, just someone in the legal coordination team who had mentioned her in passing during a conversation about a difficult case several months earlier. Josephine was an elder law attorney with 22 years of practice. Her office was on the 4th floor of a building downtown that smelled of old carpet and institutional cleaning fluid, which gave it a quality of serious purpose. Her conference table had scratches along one edge that looked like decades of folders being set down. I brought all 3 folders and the recordings. I laid everything out in chronological order and walked her through it from the beginning: the diagnosis, the POA, the canceled aid, the call log and its entries, the medication counts and photographs, the phone recordings, the assessment of our mother's condition on that February morning. Josephine listened without interrupting. She had reading glasses on a chain around her neck, and she put them on to read the call log. She read it completely, which took 8 minutes. When she finished, she took the glasses off and looked at me. She said, "You've been building a case." I said I hadn't known whose case it was supposed to be. She said, "Now you do." We talked for 2 hours and 40 minutes. I want to lay out what she told me as precisely as I can, because these are the mechanisms that determined the outcome of everything that followed. First, the POA itself could be challenged on the grounds of undue influence. To succeed, we would need to demonstrate either that our mother had lacked legal capacity at the time of signing, meaning she did not understand what the document was or what it authorized, or that she'd been pressured or manipulated into signing it. The neurologist's records from that period would be critical. Our mother had been assessed 6 weeks before the signing, and the records noted that while her short-term memory was compromised, her capacity for legal decision-making was, at that date, considered borderline. Borderline is not clear. Borderline gives you something to work with. Second, regardless of whether we challenge the POA itself, Arabella's conduct as agent was governed by a legal obligation called fiduciary duty. Under state law, a POA agent must act in the principal's best interest at all times. Failure to ensure proper medical care. Failure to manage medications. Allowing the principal to go without adequate food or appropriate home conditions. All of these could constitute breach of fiduciary duty. More significantly, and this was where Josephine's voice became quieter and more precise, depending on the evidence, they could also constitute elder abuse under criminal statute. Third, there were 2 paths available to me, and they could run simultaneously. The civil path: challenge the POA, petition for guardianship or conservatorship, seek civil damages for any proven financial misconduct. The criminal path: report to Adult Protective Services and to the State Attorney General's Elder Financial Exploitation Unit. Fourth, the civil path would protect our mother going forward. The criminal path could result in criminal charges against Arabella. One fed the other. Findings by APS could support the civil petition, and evidence gathered in the civil process could be shared with criminal investigators. Fifth, I should not confront Arabella again. Not one more time. I was not to give her any indication that I was building something. Every confrontation gave her information and gave her time to respond. I was to document, report to the appropriate institutions, and allow those institutions to exercise the authority they had. That I did not. I asked Josephine how long it would take. She said, "Faster than you think if the documentation holds up." I went home and started a 4th folder. Here is what I did over the next 6 weeks. I want to be specific about the sequence because the order mattered. I obtained a complete copy of our mother's medical records from her neurologist, her cardiologist, and her GP. As her daughter and documented primary care coordinator with years of correspondence, appointment records, and pharmacy interactions to establish my involvement, I was legally entitled to request these. The records went back 3 years. I organized them chronologically and marked the significant entries with color-coded tabs. I engaged a geriatric care manager, a licensed social worker who specializes in evaluating elder care, to conduct an independent professional assessment of our mother's care needs and current condition. I arranged this through a visit I coordinated without notifying Arabella. The care manager visited our mother during a routine Tuesday morning call I made, staying for 90 minutes. Her assessment documented nutritional deficiency markers consistent with inconsistent food intake, evidence of irregular medication management, and signs of social isolation, including diminished engagement with external activities and contacts. This assessment became the clinical foundation for everything else. I submitted the assessment, along with a formal written complaint documenting my observations and records across the prior 4 months, to the State Adult Protective Services Office. APS accepts reports from any person. You do not require legal standing. You do not require conclusive proof. You require a reasonable basis for concern about the welfare of a vulnerable adult. I had 4 months of documented concern. I filed a concurrent complaint with the Long-Term Care Ombudsman Program. This is a federally mandated office that exists in every state, empowered to investigate complaints about the welfare of adults receiving home and residential care services. The Ombudsman operates independently of APS and has authority to conduct unannounced visits and compel documentation. Simultaneously, Josephine filed a civil petition for emergency guardianship. Emergency guardianship is a court mechanism available when an incapacitated adult is at risk and existing protections are inadequate. The petitioner must demonstrate incapacity. I had neurological documentation and risk. I had the care manager's assessment and 4 months of my own records. The court scheduled a hearing for 3 weeks out, which is fast for civil proceedings and reflects the emergency designation. While all of this was in motion, I kept visiting our mother. Twice a week, without fail. I kept my call log. I kept photographing the medication organizer. I kept receipts from the groceries I bought. I kept showing up. And then I found the bank statement. It happened the way important things sometimes happen, not through investigation, but through a moment of ordinary help. Our mother asked me to find a letter she thought she had put somewhere. She said it was from the bank. We spent 20 minutes looking. The side table, the kitchen drawer by the phone, the stack of papers on the counter, the folder she kept on the shelf in the hall. We found it in a kitchen drawer behind some takeaway menus. It was a quarterly summary statement, the kind banks generate automatically to notify account holders of account activity during the period. I looked at it the way you look at something when you haven't yet understood it. A processing moment. Then I understood it. The account balance was $4,200. I stood in our mother's kitchen holding that piece of paper, and the house was warm, and the television was on in the other room, and our mother was somewhere behind me looking for a recipe she wanted to show me. And I read the balance again, $4,200. 3 years ago, when I had last had visibility into our mother's financial situation, before the diagnosis deepened, before Arabella and the POA, she had held approximately $340,000 in savings. It was a mixture of the money from our father's estate, the proceeds from selling the family home in the suburbs when she decided she wanted a smaller place, and 40 years of careful, methodical living. She had told me once, sitting at her kitchen table with a cup of tea, that the money was for her care. She said it quite specifically. It was exactly what it was for. I looked at the statement for a long time. Our mother had moved into the other room and was not watching me. I photographed the statement 3 times from slightly different angles. I made sure the account number was visible in every photograph. I made sure the balance was visible. I made sure the date was visible. I walked to my car in the driveway and called Josephine from the front seat. She told me to obtain a full account statement if I could, but not to ask our mother for access directly. If it appeared in the civil proceedings that I had been accessing financial records without legal standing, Arabella's attorney could use it against the petition. She said she would file an emergency motion for financial disclosure as a component of the civil case. This would compel production of the complete transaction history under court order. She also, during that same call, contacted the APS caseworker assigned to our mother's case and relayed what I had found. Financial exploitation of a vulnerable adult is a felony in our state. 3 elements must be established: that the victim was a vulnerable adult, documented, that the perpetrator occupied a position of trust or dependency in relation to that person, established by the POA, which was a legal instrument of trust, and that assets were taken, managed, or used in ways that were not in the victim's interest. $4,200 in an account that should have held $340,000 was not an accounting discrepancy. That same week, Josephine contacted the State Attorney General's Elder Financial Exploitation Unit. This is a specialized prosecutorial division. Not every state has a dedicated one, but ours does, staffed with investigators who have subpoena power. That means they can compel banks, investment institutions, and any other financial entity to produce complete transaction records. They can compel testimony. They operate with the full authority of criminal investigation. I did not need to prove what happened to the money. That was their function, not mine. My function was to document, report, show up, and refuse to leave. I want to tell you about the afternoon Arabella discovered that APS had been to visit our mother. She called me on a Tuesday. I was at my desk at work. I watched her name on the phone screen, and I let it ring twice before I answered. So in 2 very specific seconds of stillness, I am not sure why, except that I had learned by then to give myself a breath before any conversation with her. She said, "Did you report our mother to Adult Protective Services?" I said, "I filed a report because I had documented concerns about the quality of her care." She said several things after that, loudly and with increasing intensity. The summary: I was a jealous, controlling person who had always resented her involvement. I had gone behind her back because I couldn't accept that she was the one with legal authority. I was using our mother as a weapon in a decades-long competition. I was going to destroy what remained of our family out of spite. I let her finish. I said, "Is the antidepressant being refilled on schedule?" Silence. I said, "Is there a regular meal plan in place?" Silence. "Oh," I said, "the geriatric care manager found nutritional deficiency markers on her last assessment. Arabella said she was going to speak with a lawyer." I said that seemed like a reasonable decision. I ended the call. I noted the time. I summarized the exchange in 2 lines. I labeled the recording. The guardianship hearing took place on a Wednesday morning in a courtroom that smelled like old paper and the particular dry quality of recycled institutional air. I wore gray. I sat beside Josephine at the petitioner's table with 4 folders stacked in front of me and a calm I had been maintaining for 3 months. Through methodical effort, Arabella sat across the room with her attorney, a man with a well-cut suit and the slightly aggressive posture of someone who has decided the best defense is continuous forward pressure. She did not look at me when she came in. She looked at the back wall and then at the table. Our mother was not present. Her neurologist had submitted a written assessment of her current capacity and her care needs. The geriatric care manager testified in person. Josephine presented the documentation systematically. The call log, the photographs of the medication organizer, the APS filing, the care manager's report, the recorded calls. Arabella's attorney argued that the existing POA was a sufficient and appropriate protection, that I was a family member motivated by a personal dispute who had weaponized official reporting mechanisms, and that there was no basis for superseding a properly executed legal document. He presented no medical evidence. He presented no financial accounting. He presented no documentation of actual care. The judge asked him to address the account balance. He said he did not have the financial records before him. The judge said that was a significant problem, and she would expect them at the follow-up hearing. Then she considered the evidence for the emergency petition. The hearing lasted 4 hours. At the end of it, the judge issued an emergency temporary guardianship in my favor. She suspended Arabella's authority under the POA pending the completion of a full investigation. She ordered a comprehensive financial accounting of all transactions conducted under the authority of the POA from the date of execution. Arabella left the courtroom without speaking to anyone. Her attorney spoke to Josephine briefly at the door. Their exchange was short. I sat in Josephine's car in the parking garage outside the courthouse for a few minutes while she took a call. The garage smelled of concrete and exhaust and the faint chemical sweetness of tire rubber. Fluorescent light, the particular color of institutional fluorescence that makes everyone look slightly tired. I thought about October, about the driveway at night, about 11 minutes on a dashboard clock. Josephine finished her call. She said, "Next steps?" I said, "I want to visit my mother." She drove me to my car and I drove to Harrogate, where Arabella had moved our mother 2 months earlier after deciding, without consulting me, that the home setting was no longer manageable. The facility was not unlicensed. It was not the worst in the system. It was the kind of place that technically met its regulatory requirements and in every other way communicated that meeting those requirements was the full extent of its ambition. The smell reached me in the parking lot. Our mother was in her room, which was adequate in dimension and unsatisfying in everything else. The window faced a service area. There was no bird feeder. The chair by the window was facing away from it, which seemed like a small failure of thought. I photographed the room before I did anything else. Not because I was planning anything specific at that moment, because I had learned to photograph first and think about what I had later. I turned the chair to face the window. Then I sat with our mother for 2 hours, and we talked about nothing significant, and she held my hand once when she thought I looked tired. Which I was. The forensic accounting report was delivered to Josephine's office 6 weeks after the court order was issued. It was 47 pages. She called me, and I came in the following morning and sat at her conference table and read it. I want to tell you what it found. In the 14 months since Arabella had been named agent under the POA, the following transactions had been conducted from our mother's accounts. $87,400 transferred to a joint account held by Arabella and Adrian. These transfers were made in increments consistently below $10,000. This is a technique called structuring. Federal banking regulations require financial institutions to file reports on cash transactions above $10,000. Conducting a series of transactions below this threshold to avoid triggering those reports is itself a separate federal financial crime. Carrying independent criminal exposure. $43,000 paid to a home renovation contractor. The invoices were addressed to our mother's home address. The forensic accountant cross-referenced the contractor's records and confirmed with the contractor's own documentation that the work was performed at Arabella and Adrian's property on the north side of the city. $29,000 withdrawn in cash across 31 separate transactions over 14 months. No receipts, no documentation, no correspondence indicating what the cash was used for. Nothing. $14,000 paid to a consulting firm. The forensic accountant traced the firm's registration. It was a shell company registered in Adrian's name 18 months prior. It had no employees, no stated business activity, and no other clients. $11,200 to a travel and leisure company. The dates of the bookings, cross-referenced with social media photographs Adrian had posted publicly, corresponded to a family holiday in Portugal. The photographs showed Arabella, Adrian, and their 2 children at a coastal resort. The photographs were date-stamped. The total amount moved out of our mother's accounts in ways that could not be attributed to her care, her medical needs, her housing, or any other legitimate expense in her interest, approximately $184,600. The remainder of the account depletion was accounted for by actual care costs, utilities, groceries, and the facility fees at Thornfield. The deficit was not an accounting error. There was also the matter of the home aid billing. When the forensic accountant reviewed the transactions in detail, it emerged that for 4 months after Arabella had canceled the home aid service, the cancellation I had first noticed in December, our mother's account had continued to be charged for it. A direct debit, automatically authorized, for the agency's monthly rate. This amount had been rerouted through a secondary account that Arabella controlled. She had been charging our mother's account for care she had deliberately canceled and was not providing. I read all 47 pages. When I looked up, Josephine was watching me. She said, "The AG's office received all of this under the financial disclosure order. They've had it for a week. They've been running a parallel investigation since the APS referral." I said, "How long has the financial exploitation been going on?" She said, "The forensic accountant's analysis suggests it started within 60 days of the POA execution." October. The POA was signed in October. By December, structured transfers were already moving money out. I thought about all the times I had been told I was catastrophizing. I thought about October and the driveway and the 11 minutes. I drove to Thornfield after the meeting and I walked to our mother's room and I sat with her for an hour. She was having a good day. She showed me a photograph she had found while going through an envelope of old pictures. the two of us on a beach somewhere, very small children, squinting into the sun. She said she couldn't remember where it was taken. I said I thought it was from the summer we went to the coast with Aunt Patricia. She said, yes, that sounds right. You were always sunburned. I was doing the guardianship transition simultaneously with everything else. Moving our mother to Harrogate, the facility I had chosen, required a care plan review, a transfer of medical records, coordination with the facility's admissions team, and legal documentation confirming my authority as guardian. Josephine handled the legal aspects. I handled the logistics. I visited Harrogate 4 more times before the admission. Each time I spoke with different staff, I asked the nursing team about their medication management protocol, electronic administration records, third-party audited quarterly. I asked about staffing ratios, above state minimum at all shifts. I asked about incident reporting rates and the facility's record in state inspections. The most recent inspection had 2 minor citations, both resolved within 30 days, both documented in the facility's public compliance record. I asked the activities coordinator how long she had been there. 9 years. 9 years is a data point. Staff who stay in elder care facilities for 9 years do so because the management creates conditions worth staying in. Our mother moved to Harrogate on a Tuesday morning. Her room looked out over a garden with raised beds. In summer, residents who wanted to could tend the beds. In late winter, the garden was bare, but light came through the window in a way that made the room feel honest. She sat in the chair by the window the first afternoon. There was a bird feeder on a post in the garden, currently empty. She watched the empty feeder for a while. She said, "This is better." I told her I thought so too. I made a note to bring bird feed on my next visit. The investigation by the AG's Elder Financial Exploitation Unit proceeded across 4 months, running in parallel with the criminal investigation that APS had triggered through the law enforcement referral. I was interviewed by investigators twice, in 2 sessions of approximately 90 minutes each. I gave them copies of everything. All 4 folders, the call logs, the recordings, the photographs, the care manager's report, the medication count records. They had the financial records. They had subpoenaed the banking transaction history going back to the date of the POA. They had the contractor. They had the travel bookings. They had the shell company registration documents. This is the thing about financial crimes against vulnerable adults that Arabella apparently had not fully considered. Financial institutions are required by law to maintain complete transaction records. There is no version of financial exploitation that does not leave a paper trail. You cannot explain $87,400 in structured transfers as legitimate care expenses. You cannot produce receipts for $29,000 in cash withdrawals that served a vulnerable adult's interests. You cannot make a forensic accountant unread a shell company's registration. She had assumed that our mother's dementia would make her an unreliable witness, which was true, but largely irrelevant to a case built on financial records and contractor testimony. She had assumed that I, without legal standing, could not access the financial records. Also true until the court order. She had not accounted for APS. She had not accounted for the ombudsman. She had not accounted for a forensic accountant appointed by a judge. She had not accounted for an AG's office with subpoena power. She had not accounted for 11 months of a call log and a box of folders under a desk. The arrest happened on a Friday morning. I was at work when Josephine called. I was at my desk with a cup of coffee that had gone cold beside my keyboard, looking at a spreadsheet without seeing it. My phone lit up with her name. She said, "They picked her up this morning, both of them, Arabella and Adrian. The charges are being announced this afternoon." I said, "Okay." There was a pause. She said, "How are you doing with this?" I thought about it honestly. I was looking at my screensaver, which was a photograph I had taken at the coast the previous summer. Gray water under a gray sky, very still, very flat. I had taken it because I liked how quiet it looked. I said, "I need to arrange a care plan review for my mother. The new facility wants a 60-day assessment." Josephine said, "Of course." I said, "Thank you for all of it." She said, "You did most of it." The charges filed were financial exploitation of a vulnerable adult, a second-degree felony in our state carrying up to 15 years, theft by deception, elder abuse in relation to the neglect, the canceled aid, the medication failures, the inadequate nutrition, the conditions at Thornfield. Adrian was charged separately with conspiracy and receipt of stolen property. Arabella hired a private defense attorney who was very good at his job. He gave a statement outside the arraignment that characterized the charges as a family dispute that had been criminalized, a sister's vendetta given the shape of a prosecution. He said Arabella had always acted with her mother's best interests at heart. He used the word love several times. I watched the statement on the evening news in our mother's room at Harrogate. Our mother was asleep in the chair beside me. The news anchor moved on to the next item. I turned the television off and sat in the quiet for a moment. The trial lasted 8 days. The prosecution's case rested on the forensic accounting, the complete banking transaction records obtained under subpoena, the contractor's testimony, the travel records, and the registration documents of the shell company. The geriatric care manager testified about the conditions she had observed at the home visit. The APS caseworker testified. The ombudsman investigator, who had conducted a subsequent review of the Thornfield facility, testified about conditions there. Our mother's neurologist testified about her capacity, her care needs, and the medical consequences of the medication mismanagement. I testified. I was on the stand for 2 hours and 15 minutes. Arabella's attorney worked methodically through the characterization that I had filed complaints out of family rivalry and personal grievance rather than genuine concern, that I was a controlling older sister who had resented Arabella's assumption of the caregiver role and had used official channels as an instrument of revenge. He asked me about our relationship over the years. He asked about money. He asked whether I had expected to be named in our mother's will, and whether the POA had changed my expectations regarding the estate. I answered every question briefly. I answered every question accurately. I looked at the prosecuting attorney rather than at Arabella when I spoke. What I was not going to do on that stand was cry. What I was not going to do was display the kind of visible pain that could be characterized as evidence of personal motivation rather than factual testimony. I had 4 folders. The jury would receive those 4 folders, along with 47 pages of forensic accounting and a contractor's invoice addressed to our mother's house for work done at Arabella's. The jury deliberated for 11 hours. The verdict was guilty on all counts. The sentencing took place 6 weeks later. I was in the courtroom. Arabella wore a dark suit. She looked thinner than she had at the start of the trial. Her attorney made a statement about remorse and about her role as a mother, and about the damage a prison sentence would cause to 2 innocent children. The judge listened to all of it. The sentence was 6.5 years. Adrian received 3 years and a $90,000 fine. The sentencing judge noted in her formal remarks the particular quality of the breach involved, that a person given a position of intimate family trust over a vulnerable adult had systematically and deliberately used that position for personal financial gain while allowing that adult's physical and medical welfare to deteriorate. I noted the time the sentence was announced. Then I drove to Harrogate and brought bird food for the feeder in the garden. The civil recovery proceeded alongside the criminal case and produced outcomes that I want to describe separately because they were the part that most directly shaped the remainder of our mother's life. Through the civil proceedings, Josephine had obtained not only the emergency guardianship, but eventually a full permanent guardianship and conservatorship. The conservatorship giving me legal authority over financial decisions as well as personal ones. This replaced the POA entirely and with court oversight, meaning my own decisions as conservator were subject to periodic review by the court. I considered that appropriate. As conservator, I engaged an estate litigation specialist to pursue civil recovery of the stolen funds. The joint accounts had been frozen by the criminal court as part of the sentencing. A civil recovery judgment was obtained against both Arabella and Adrian, which attached to their personal assets, including the renovated property. That renovation, which had been funded with $43,000 of our mother's money, had increased the property's assessed value. We placed a lien on it. There is a particular irony in this that I have thought about more than once. We did not recover $184,600. Recovery in financial exploitation cases is rarely complete. Assets are spent, moved, dissipated. We recovered approximately $94,000 across the civil judgment, the account seizures, and the resolution of Adrian's negotiated settlement. It was enough to fund our mother's care at Harrogate for an extended period at a high level of quality. It was enough to cover the retroactive claim for the fraudulent homemade billing. It was not everything. It was sufficient. I want to step back from the narrative for a moment. and say something about what this experience showed me about the systems that exist to protect elderly people and the significant gap between those systems existing and those systems functioning. Every mechanism I used was available to me from the beginning. APS, the Ombudsman, the Elder Law Attorney, the Guardianship Petition, the AG's Exploitation Unit, these existed before any of this happened. They exist in some form in every state. They are staffed by people who are genuinely trying to do their jobs. None of them activated themselves. APS requires a report. The Ombudsman requires a complaint. The Guardianship Court requires a petition. The AG's unit requires a referral, which itself comes through APS, which requires someone to have filed a report. The protection was not passive. The protection required a person to initiate it and to keep initiating it, and to have the professional background to know which thing to initiate in which order. I had that background. I had worked in healthcare administration for 11 years, and I understood how systems were structured and where the gaps were. I understood documentation and fiduciary language and the specific vocabulary of elder law. Most family members in this situation do not have that background. Most family members in this situation are also grieving, exhausted, and being actively told by the person exploiting their parent that they are catastrophizing. I want to be very clear that I did not succeed because I was exceptional. I succeeded because I was methodical in a situation specifically designed to make methodical action feel unnecessary. I succeeded because I refused to accept the frame I was being given. That my concern was disproportionate, that things were being handled, that love was sufficient evidence of care. Love is not sufficient evidence of care. Care has a paper trail. The documentation mattered more than anything else I did. Before the elder law attorney, before the APS report, before the guardianship petition, before any of it. The call log and the photographs and the medication counts and the recorded calls were not legal strategy. They were just watching closely and writing down what I saw. That is accessible to anyone. Here is the practical sequence for anyone who needs it. Start a written log immediately. Date every entry. Record what was asked and what the response was. Record what you observed. Do not rely on memory. A call log with 50 entries is a document. Your memory of 50 calls is testimony you will be asked to support. Photograph small things, medication organizers, refrigerator contents, the state of the living space, mail that has accumulated. These images have dates embedded in the file data. They cannot be argued with the way recollections can. Record your conversations if your state allows it. Look up the law in your state first. Single-party consent states allow one person in the conversation to record. This requires 5 minutes of research. Consult an elder law attorney, not a general family lawyer. The distinction matters. The legal architecture of POA challenges, guardianship law, and financial exploitation prosecution is specialized. A consultation is not an immediate commitment to litigation. It is information. File an APS report if you have a reasonable basis for concern. You do not need proof. You need concern and a willingness to document it. APS investigates. That is their function. File with the Ombudsman if there is any residential or home care component. The Ombudsman operates independently, has different investigatory authority, and produces an independent record. Petition for guardianship if you believe the existing legal protections are being used against the person they are supposed to protect. This is the mechanism that gives you legal standing. Without it, you are a concerned family member. With it, you are a court-authorized protector with rights the court will enforce. Do not tip off the person exploiting your parent. Every confrontation is information given to someone who will use it. Document, report. Let the institutions move. They are slow, they work. 6 months after the sentencing, I received a letter from the Elder Law section of the State Bar Association. They had been informed of the case through the AG's office, and they were developing a practical guide for family members navigating elder care crises, specifically around POA concerns, documentation strategies, and the reporting processes available to them. They were seeking written accounts from people who had been through the process. They were asking if I would contribute. I read the letter 3 times. Then I called Josephine and asked her to review whatever I wrote before I submitted it. She said, "Obviously. How long will it take you?" I said 2 weeks. It took 1. Our mother's birthday was the following March. We had a small party at Harrogate. Myself, 2 of her friends from before everything. The neighbor she talked to on the telephone on Tuesdays. Josephine came briefly, which I had not expected. She brought a succulent in a terracotta pot, something small and structured, she said, and easy not to kill. Our mother was clear that day in the particular way she sometimes was, especially in the mornings. She told a story about her own mother that I had never heard before. Something from her childhood, a summer, a misunderstanding that had resolved into something funny. She laughed when she told it, a proper laugh, the kind that made her tip her head back slightly. She ate her cake with attention. Yeah, she reached for my hand twice during the afternoon and held it both times for exactly as long as she wanted to. I thought, this is what I was protecting. Not a legal principle, not the money, not even justice exactly. This. Her hand in mine and a story I hadn't heard, and a window looking out over a garden in late winter where the raised beds were bare and waiting. The bird feeder was empty. I made a note. I refilled it the following Tuesday. The birds found it within 2 days.